talk about parental decision-making responsibility and allocating it in Colorado, we're not talking about everyday decisions. We're not talking about what time kids go to bed or whether they're allowed to watch rated R movies or what they have for dinner or homework. What the courts are talking about when they allocate decision-making responsibility is who is responsible for making the major decisions in a child's life. And those decisions are things like, where is the child going to school? What religion is the child going to be raised in? What major non-emergency medical procedures is the child undergoing? And these are things like elective surgery, or, as was relevant to my article in this discussion, vaccination.
And what are the factors that go into decision making by the court if we ultimately can't decide, or parents can't decide on decision making?
So it depends on whether the court is allocating decision-making responsibility for the first time, or if they are modifying decision-making responsibility that has already been allocated. So the court considers all of the statutory best interests factors that go into allocations of parenting time that I'm sure you all have talked about before. But there are three additional factors that the court considers when allocating decision-making authority in the best interests of the child. The first of those is there credible evidence of that the parties have been able to cooperate on major decisions in the past? Because if the party's history is riddled with a bunch of disagreements about these issues already, the court's not necessarily going to think it's in the child's best interest to continue trying to make those decisions jointly going forward. The second sort of special factor is whether the past pattern of involvement of the parents with the child reflects a system of values and commitment and mutual support that indicates that having mutual decision-making is going to be positive for the child. The third is whether an allocation of decision-making, mutual decision-making responsibility would promote continuing contact between the child and each of the parents. Now, there are also considerations that need to be taken into account in the event there has been domestic violence. But in general, those are the three big factors that a court looks at when allocating decision-making authority for the first time. And I think it's important to say here that it's not an all or nothing proposition. The parties can have joint decision-making authority over all the major decisions. One party can have sole decision-making authority over all the major decisions, or you can have combinations. So the parties can have joint decision-making authority over, religious decisions, but there's one party or another has sole decision-making authority over medical decisions, and so on and so forth. There are a lot of different permutations. So the process starts with a motion. The person who wants to change decision-making from, for example, joint to sole, or for that matter, sole to joint, needs to file a motion with the court asking the court to make that change. And the standard that the court follows for joint decision-making for a modification of decision-making, is that the court, and this is quoting from the statute, shall not modify a decree allocating decision-making unless it finds, upon the basis of facts that have arisen since the prior decree or that were unknown to the court at the time of the prior decree, that there has been a change in circumstances of the child or the parents, and that the modification that is being requested is necessary to serve the best interests of the child. And this sounds like we're just going back to the best interests of the child, but there's an additional wrinkle when it comes to modification. The statute that we're talking about, 1410-131, that governs modification of decision-making, says that when figuring out whether a modification is necessary to serve the best interests of the child, the court must retain the prior allocation of decision-making responsibility. So the court can't change it unless it finds that one of the following things has occurred. So unless it finds that the parties have agreed to the modification, in which case, you're not really going to court. Unless it finds that the child has been integrated into the family of the person who wants the change, and that integration necessitates a change of decision making. If it finds that there has been a modification of parenting time warranting a modification of decision making, if the party who was supposed to make the decisions has consistently been ceding that responsibility to the other party, or, and this is the one that gets litigated most often, if the current allocation of decision-making authority would endanger the child's physical health or significantly impairs their emotional development, and that the harm likely to be caused by the change of environment is outweighed by the advantage of the change to the child. So the first four of those factors, agreement or changes in parenting time or consent, those are litigated very, very rarely. I have only had experience to litigate some of those one time. Certainly when in the vast majority of circumstances that I have seen, when parties are asking to change decision-making, they are doing it under the last of these factors, which we'll call the endangerment factor, and which is to say that the person who wants to make the change is saying the current allocation of decision-making authority endangers the child or significantly impairs their emotional development, and we need to make the change for that reason.